well versed in. I've been doing it a very long time. So the judge should be mindful of the rules. Then the judge asks which rules. Then I point the judge to the rules, the specific rules, what the order says. And the judge says he's already made his decision. I told him his decision was in error. He couldn't have made the decision he made. He was not permitted, or he's not permitted under the law to make the decision he made, because he's made orders. And we do not know on which authority he made those orders. Is it that someone made that prayer before the court and the orders were drawn, or that he did so motu? Because if he did, the rules are clear. Then this judge proceeds to refer to the rules. And in reference to the rules, he realized that what I'm saying is true. So he wants to play smart and says, we don't have any processes on the file. He's not going to listen to me anymore. I told him, no, he should refer to the file. 3 documents down, this is there. 5 documents down, this is there. This is because I'd come to prep. And then he checks and he sees it, then he gets visibly pissed. So he asks who is the next, or who is the most senior there. Fortunately, there was someone senior to me, very, very senior, about almost 20 years, 25 years, sitting in the courtroom. And then my lord says, oh, let's go to chambers. In my head, I was like, Baku. Chambers. So all things being equal, we went to the chambers, and I explained the procedure and the process to the court in chambers. He didn't like it. He didn't want to agree. So he asked the opinion of counsel on the other for senior counsel. And counsel told him, yes, whatever I've told him is the law. And the law is clear. So it is either he is doing what I'm asking him to do, or he's finding a way to remedy the situation. So the long and short of it is that he gave an order for something to be done, which the disobedience of the said order would have led to contempt, the kind which would require that the contempt not be jailed. Now, there was no application before him. No application had been brought before him praying for that relief, or praying for the grant of any such relief or orders of the court. He proceeded to do the said thing on the powers he had as a judge, which is allowed. But then the requirement is that you state that you are doing the siomotu, not that you have heard someone's prayer and have read someone's affidavit, so you are granting the said order, which he did. So I asked him to point us to where the motion was filed, what the motion was praying for, who moved the said application, whether the other side was served. Because all of this means that you have to put everything on record. So if you have offered an order based on your rules, you ought to be able to prove to us where the right thing was done. It was like,